Okay, so today we will continue with chapter 2 starting from Article 1169. Now, Article 1169 talks about delay. So, Article 1169 state that those obliged to deliver or to do something incur delay from the time the obligee judicially or extrajudicially demands from them the fulfillment of their obligation. So, again, when does delay begin? From the time the obligee or the creditor judicially or extrajudicially demands from the obligor the performance of the obligation. Okay, so general rule, no demand, no delay. That is under Article 1169, paragraph 1. However, in the preceding paragraph, it states there that demand by the creditor shall be necessary in order that delay may exist. So these are the exception to the general rule. So again, general rule, no demand, no delay. So there are three cases wherein judicial or extrajudicial demand is not necessary. So by the way, when you say extrajudicial demand, that is demand made outside of courts. So usually, what you can go to a lawyer and you can write a demand letter so that it would be documented. However, you can also demand verbally or through text or through email or through calls because Article 1169 does not distinguish. That is extrajudicial demand. However, when you say judicial demand, that is demand that is done through the courts. Now, what are the three cases where demand is not necessary in order to incur delay? Number one, when the obligation or law expressly so declares. Number two, when the nature and circumstance of the obligation, it appears that the designation of time when the things to be delivered or the service to be rendered was a controlling motive for the establishment of the contract. So time is of the essence. And number three, when the demand would be useless as when the obligor has rendered it beyond his power to perform. Okay, so number one, before we go to the exceptions to the rule, let us first discuss what is delay. So delay or demand, that is the failure. What is delay? So delay or mora, no, it is a failure to perform the obligation in due time because of dolo or malice or culpa or negligence. So when you say dolo, that is intentional delay. When you say culpa, that is delay through negligence. Okay, you did not intend to delay, however, it was still delayed. Okay. So, what are the kinds of mora or delay? There are three kinds of mora or delay. Number one, we have mora solvendi. So, when you say mora solvendi, it is the delay because of the debtor. So, it is the fault of the debtor, and the debtor failed to fulfill the obligation. Okay, so for example, that's I think self-explanatory. Mr. A failed to deliver the thing on February 1 because he was tired. That is mora solvendi. So there are two kinds of mora solvendi. Mora solvendi ex-re, that is in cases of an obligation to do, and mora solvendi ex persona in cases of an sorry. Mora solvendi ex-re x-ray in cases of an obligation to give, and because it's a real obligation, and mora solvendi ex persona when the obligation is an obligation to do or a personal obligation. So again, mora solvendi, it is the delay was because of the debtor. We have mora acipiende. The delay is because of the obligee or creditor. So there is a delay to accept the delivery of the thing, which is the object of the obligation. Okay, so mora solvendi, the delay of the debtor to deliver, the delay in the fulfillment of the obligation. Mora acipiende, the delay of the creditor of the or the obligee to accept the delivery of the thing. So for example, Mr. A was obliged to deliver a thing on February 1. However, Mr. A was not able to deliver because Mr. B could not accept it because of quarantine rules. He cannot enter the said area, or for example, or he was quarantined, or for whatever reason. So the delay was not because of the debtor, it was because of the creditor. So that is mora acipiende. And we have compensatio morae. Compensatio morae, there is default on part of both parties in cases of reciprocal obligation. So we will discuss that in the third paragraph of 1169. Okay, so those are the kinds of mora or delay. Now, again, we go back to the general rule, no demand, no delay. However, the law provides for three exceptions. First is when the obligation or the stipulation in the contract or the law expressly so declares. Now, what are examples where the law expressly so declares? So, there's no need to demand in order for a person to commit delay. For example, the payment of income tax. The payment of income tax is specifically provided by the law. So there is a specific date on when to pay your income tax. Failure to pay your income tax on the stipulated date, there is already delay, there is already penalty. So the BIR does not need to have a demand letter now in order for a person to or the taxpayer to incur delay, because that is an exception to the rule when the obligation or the law expressly so declares. Second, when the nature and the circumstances of the obligation appears that time was a controlling motive. Time is of the essence. Now, for example, an obligation to deliver a birthday cake. When do you deliver a birthday cake? So, more often than not, you deliver the cake on the birthday of the celebrant. Now, for example, the birthday of the celebrant is February 1. So, it means that you have to deliver the cake on or before February 1 or on February 1. Now, the fact that you deliver the cake on February 2, there is already delay despite the obligee not being able to demand. Why? Because time is of the essence. Time was the controlling motive of the obligation, or for no, so it would be useless to have a birthday cake the day after the birthday. Or for example, an obligation to deliver a wedding dress. No, so when do you deliver a wedding dress? You deliver a wedding dress the day before the wedding. No, so why would you deliver a wedding dress the day after? So there is no need to demand in order for the obliger to incur delay in these kind of cases, because time was a controlling motive of the contract or of the obligation. And the last exception is when demand would be useless, as when the obliger has rendered it beyond his power to perform. Now, for example, Mr. A promised to deliver Mr. B a house and lot in a contract of sale. Now, prior to the delivery of the house and lot, the said house and lot of Mr. A was executed by the court. When you say executed by the court, it was taken by the court in order to be sold in order to satisfy the debts of Mr. A. Okay, so that falls on the third exception, that the demand would be useless because Mr. A can no longer deliver the said house and lot because it is no longer under his possession. It is no longer under his ownership. So he has no capacity to deliver it. So when the demand would be useless, as when the obliger rendered it beyond his power to perform. The obliger could no longer perform the delivery, in our case, the said house and lot, because it is no longer his. So again, in these three cases, there is no need to have a demand in order to incur delay. The moment that the situation falls under these cases, there is automatic delay despite no demand. Now, why is it important to distinguish if there is a delay in the fulfillment of the obligation? Now we go to 1170. So 1170 states there that when in the performance of their obligations are those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who are in any manner contravene the tenor thereof are liable for damages. So Articles 1170 does not state that it may, if the obligor or if the obligee. So it could be any. Now it could be the obligor or it could be the obligee. Oh, before I forget, we go back to paragraph 3 of 1169 in cases of reciprocal obligation. Okay, we go back to Article 3, 1169. So, paragraph 3 states there, in cases of reciprocal obligation, neither party incurs delay if the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. From the moment one of the party fulfills his obligation, delay by the other begins. So, what are the examples of a reciprocal obligation? The most common example of a reciprocal obligation is a deed of sale. The seller has the obligation to deliver the thing, while the buyer has the obligation to deliver the payment. So when no, none of them or both of them does not do anything, then there is no delay. When the buyer does not deliver the thing, and when the seller does not deliver the thing and the buyer does not give the payment, then there is no delay, even if they agreed to do the same on February 1. However, the moment the buyer pays the seller and the seller does not simultaneously deliver the thing, then the seller already incurs delay. So there is no need to demand because the law states that from the moment one of the parties fulfills his obligation, delay by the other begins. Or for example, the seller delivers the thing and the buyer fails to give the payment simultaneously or on the date provided for, there is no need to demand because the delay of the other begins from the moment the seller delivers the object of the obligation. So that is 1169 paragraph 3. Okay, so now let's move on to 1170. Again, why is there a need to determine if there is delay or there is fraud or negligence? Because those who in the performance of the obligation does any of the enumerated under 1170, they shall be liable for damages. Okay, so first, we always hear in civil law, we always hear the word damages, damage, injury. So, are these three the same? Because in layman's term, usually it is interchangeably used. But legally, these three words mean different things. Now, when you say injury, that is the legal invasion of a right. That is a legal invasion of a right. When you say damage, that is the hurt, loss, or harm which results from an injury. So the injury is the act of invading a right of another. The damage is the result of the injury. And the damages, that is the recompense or compensation awarded for the damage suffered. So you have to have an injury first and then damage in order to have damages. Okay? So that is the difference between injury, damage, and damages. So, 1170 talks about breach of obligation. So there are two kinds of breach of obligation. You have the voluntary breach of obligation and involuntary breach of obligation. The involuntary breach of obligation, this is due to fortuitous event and the debtor will not be or will be exempted from liability. Now, voluntary breach of obligation, that is what 1170 is all about. So, how do you voluntarily breach an obligation? Through fraud or dolo, through negligence or culpa, through delay, default, or mora, these are the same, and contravention of the tenor of the obligation. So, these are the four modes of voluntary breaching an obligation. Now, what do you mean by fraud? No? Fraud refers to all kinds of deception, whether through insidious machinations, manipulation, concealment, or misrepresentation, that would lead an ordinary prudent person into error after taking the circumstances into account. So when you say fraud, that is ilad. That is pangilad. So there are two kinds of fraud. We have dolo causante or causal fraud and dolo incidente or incidental fraud. Now, what is the difference between a dolo causante and dolo incidente? When you say dolo causante or incidental fraud, the fraud which induces a party to enter into a contract. So, because of the fraud, the party entered into a contract. And then, because of such fraud, the contract is voidable. Avoidable. Though we will discuss what is avoidable contract later on the later part of contracts. No, so again, when you say dolo causante or causal fraud, it is because of the fraud that the person entered into the contract. So, for example, A talked to Mr. B to buy a diamond ring, for example, a diamond ring because Mr. A said that this diamond ring is an original Swarovski diamond and no, it has a certificate, so whatsoever. It's a real diamond. And because Mr. B, who is not an expert jeweler, he was enticed by the sweet talks of Mr. A and decided to buy the ring. So what is that kind of fraud? That is dolo causante or causal fraud. Because of the misrepresentations of Mr. A, Mr. B entered into the contract. Okay. And then we have dolo incidente or incidental fraud. It is the fraud. The fraud was not the reason why the party entered into a contract. So when you say incidental fraud, there was fraud in the performance of an obligation, and that is what 1170 is talking about. That is the kind of fraud that 1170 is talking about. For example, Mr. A promised to deliver Mr. B a new cell phone, brand new cell phone. Okay, however, Mr. B deliberately delivered a second-hand cell phone. So that is incidental fraud, fraud in the fulfillment of an obligation. Thus, Mr. A shall be liable for damages. Okay, so that is fraud. Now we go to negligence or culpa. So what is the difference between fraud or dolo and negligence or culpa? When you say fraud, there is a deliberate intent to cause damage or injury. So, deliberate or intentional, that is what is fraud. When you say culpa or negligence, it was not intentional. However, the damage was due to the lack of care or diligence. A failure to exercise the diligence required. So, that is negligence or culpa. And there is actually no specific definition of negligence because, again, negligence is dependent on the time, circumstances, and place of the obligation. Okay. So there are several kinds of negligence. We have civil negligence, that is culpa contractual, and culpa aquiliana or quasi-delict. However, the negligence that is talked about in Article 1170 is culpa contractual, or the fault or negligence of the obligor by virtue of which he is unable to perform his obligation arising from a pre-existing contract. Okay, so again, Article 1170 is about culpa contractual, the negligence of failure to perform an obligation, a pre-existing obligation, because of negligence. So again, Article 1170 talks about culpa contractual and not really culpa aquiliana. Okay, and because of such negligence to perform an obligation, the debtor or the obligor shall be liable for damages under Article 1170. Okay, and then we already discussed delay, default, or mora. And then we have the fourth mode, voluntary breach, which is in contravention of the tenor of the obligation, which basically means there is a violation of a contract or a breach of contract. So, if there are any provisions or stipulations in the contract or in the obligation that was not followed, then you could be liable for damages. Now, under the Civil Code, there are 6 kinds of damages. In order to easily remember them, we use the mnemonic mental. No, mental. M is moral, E is exemplary, N is nominal, T is temperate, A is actual, and L is liquidated damages. So these are the 6 kinds of damages mental. Okay, let's start with moral damages, letter M. Moral damages, these include physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. Okay, this is a compensation for the feelings, no, for the negative feelings because of the breach. Okay, so that is moral damages. Although they are incapable of pecuniary computation, of course, because you cannot compute how much is the worth of your anxiety or your depression or wounded feelings. However, it is now dependent on the court how much moral damages should be awarded. And then that is M, mental, moral damages. And then we have E, exemplary or corrective damages. So when you say exemplary or corrective damages, they are imposed by way of an example or correction for the public good in addition to the moral, temperate, and liquidated or compensatory damages. Okay, so there is exemplary. And then letter N, there is nominal damage. When you say nominal damage, in order that a right of a plaintiff which has been violated or evaded by the defendant may be vindicated or recognized. So you can only recover nominal damages if you cannot recover actual damages. Okay, so if you cannot go for actual damages, you can go with nominal damage. And then T, we have temperate or moderate damages, which are more than the nominal but less than the compensatory damages. So these may be recovered when the court finds that some pecuniary loss have been suffered, but its amount cannot be, from the nature of the case, be provided with certainty. Okay, but this is less. This is more than the nominal damages, but less than the actual damages. Okay, and then when you say actual damages, these are the damages that is actually proved through receipts. Okay, so if you cannot claim for actual damages because you have no receipts, the damage is incapable of pecuniary estimation, you can go for nominal damage. However, if the court believes that you need more than nominal damage, then the court can award you with temperate or moderate damages. So you can only choose one between the three, actual, nominal, or temperate. They cannot go together. So you can file for moral damages and exemplary damages with actual damages or nominal damages or temperate damages. So you can have the moral and exemplary with the other kinds of damages, and then liquidated damages, those agreed upon by the parties to a contract to be paid in case of breach. So Nominal damages cannot be demanded if it is not stipulated in the contract. So nominal damages must be stipulated in the no, sorry, liquidated damages must be stipulated in the contract in order to be claimed. So liquidated damages comes in the form of a penal clause in a contract. So in case there is breach of contract, the one who breached the contract shall be liable for 1 million. So that is liquidated damages. Again, you cannot claim liquidated damages if it is not stipulated in the contract. Okay. Now we go to Article 1171. It states there that responsibility arising from fraud is demandable in all obligations. Any waiver of an action for future fraud is void. So when there is fraud in an obligation, it is demandable. Even if you sign that if I would be defrauded in this obligation, I will not file a case. No, that is not allowed. That is provided under 1171. So the said waiver shall be void. So you cannot waive your right to an action for future fraud. That is, when you say action, that is a civil or criminal judicial proceeding or what we commonly know as a case. So because this is civil law, we file a civil case or a civil judicial proceeding. Now we go to Article 1172, responsibility arising from negligence in the performance of every kind of obligation is also demandable. So just like fraud, when there is negligence in the performance of obligation, it is demandable. However, such liability may be regulated by courts according to the circumstances. So, in cases of negligence, it should be regulated by the court. Why? Because I have said negligence has no exact definition. It is dependent on the circumstance, the time, and place of the obligation. Okay. 1173. The fault or negligence of the obliger consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the person, of time, and of the place. Okay. However, when negligence shows bad faith, the provisions of Article 1171 and 2201, paragraph 2 shall apply. So when you say negligence in bad faith, that is tantamount to fraud. So when it's tantamount to fraud, it is demandable. Okay. If the law or contract does not state the diligence which is to be observed in the performance, that which is expected of a good father of a family shall be required. So you go back to 1163. The duty of the obliger to observe the diligence of a good father of a family if the law or stipulation does not provide for what kind of diligence is to be exercised. So again, negligence is the omission of the diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons and of the time and of the place. So there is no exact definition that act is negligent, because it depends on the circumstances at the time and the place. So that is 1163. And then we have 1173. Now we go to 1174. Except in cases expressly specified by law or when it is otherwise declared by stipulation or when the nature of the obligation requires assumption of risk, no person shall be responsible for those events which could not be foreseen or which, though foreseen, were inevitable. So that is what you mean by fortuitous event. So when you say a fortuitous event, it is an event which cannot be foreseen or which, though foreseen, is inevitable. So that is a fortuitous event or commonly known as act of God. So what are examples of these? These are actually natural occurrences such as floods or typhoon. No, because we know we cannot foresee it. No? But for example, typhoons, you can foresee a typhoon. However, it is inevitable, meaning you cannot stop it from happening. So if that kind of event falls under such definition, then that it is considered a fortuitous event. In cases of fortuitous event, the obligor shall not be responsible. Okay. And then you compare it with act of man such as riots, strikes, or war. So act of man is different from act of God or fortuitous event, and the rules of fortuitous event does not apply in cases of acts of man. Okay. So what are the elements of a fortuitous event? It is unforeseen and independent of the will of the human, of man. And then it must be impossible to foresee, or if foreseeable, impossible to avoid. So as I have said, it's inevitable. It will happen no matter what. So for example, typhoons, you cannot do anything to stop a typhoon. And then the occurrence must have been such as to render it impossible for the debtor to fulfill their obligation in a normal manner. For example, an obligation to deliver, and there is a typhoon. Of course, you cannot deliver during a typhoon. So that is a fortuitous event. There is no delay. And then the obligor must have been free from any participation in the aggravation of the resulting injury to the creditor. So the obligor does not add any injury to the damage of the creditor. So 1174 again states that in cases of fortuitous event, the person or the obligor shall not be considered liable. Okay. However, there are cases where fortuitous event, even if there was a fortuitous event, the obligor shall be liable. In article, what was that? 1165. No, in article 1165, when there is already delay, 1165 paragraph 3, if I'm correct. Let me check first. 1165. So, okay, yes, right. 1165 paragraph 3 it states there that when there is delay, or the obligor promised to deliver the same thing to two or more persons not having the same interest, he shall be liable in cases of fortuitous event in case of loss. Okay. Now, is carnapping considered a fortuitous event? There is a case provided in your book. However, Supreme Court said that carnapping is not a fortuitous event because it can be foreseen and it can be prevented. Okay. So again, to constitute a fortuitous event, it cannot be foreseen, or if foreseen, cannot be prevented, because carnapping can be prevented if you exercise proper diligence. Robbery, again, that is not considered a fortuitous event. Okay. We have 1175, usurious transactions shall be governed by special law. So we have the usury law. So when usury law provides for the ceiling in cases of interest. However, I believe usury law is suspended right now. Okay, 1176 paragraph 1 is a disputable presumption. Now, what does 1176 states? The receipt of the principal by the creditor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. Now, for example, you have a principal loan of 10,000 and an outstanding interest of 5,000 of 1,000, for example. So when Mr. A paid the loan, the creditor did not say that this shall be applied to the interest. So because the creditor did not say that it shall be applied to the interest, then there is a disputable presumption that the interest is already paid. Okay? Because the creditor did not make a distinction that the said payment shall be applied to the interest. But again, it is a disputable presumption, meaning it may be contradicted or overcome by other evidence, unless the creditor can show no, there is still an outstanding interest and the payment was applied to the interest instead of the principal. So that is Article 1176, Paragraph 1. Paragraph 2 is another disputable presumption. The receipt of a later installment of a debt without reservation as to prior installment shall likewise raise a presumption that such installment has been paid. Now, for example, Mr. A has an installment, April, May, June, July. So, Mr. A paid Mr. B for the month of July. So, if Mr. A, no, Mr. A paid. If Mr. B received the payment for the month of July, then there is a disputable presumption that the month of April, May, and June are already paid. So again, that is a disputable presumption. Mr. B can present evidence to contradict such disputable presumption. And that ends, oh no, we don't have PDI. We have, okay. So that is a disputable presumption. And then we go to 1177. I forgot this 11. So 1177 talks about the remedies of a creditor. Now, what are the remedies of a creditor? There are three remedies of a creditor stated in 1177. Okay, so the creditors, after having pursued the property in possession of the debtor to satisfy their claim, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn acts which the debtor may have done to defraud them. So 1177 talks about three actions, and this must be done in a successive manner. So you go number 1 and number 2 and then number 3. You cannot start with number 3. So you start with number 1. You exhaust the properties of the debtor through levying by attachment and execution upon all the property of the debtor. So if the debtor cannot pay the obligor, he may go for attachment and execution of his property. Now, for example, the attachment and execution of his property is not enough. What can the creditor do? He may go for action subrogatoria. So what is action subrogatoria? That is to exercise all the rights and actions of the debtor. So for example, the debtor has a building and it has tenants. So if the attachment and execution of property is not enough to pay for the debts of the debtor, then he may subrogate the rights of the debtor to collect the rents until the debt is fully paid. So that is action subrogatoria. And lastly, if it is still not enough despite action subrogatoria, he may go for action pauliana. This is to seek rescission of contracts executed by the debtor in fraud of their rights. Now, what is action pauliana? For example, Mr. A has a 1 million debt to Mr. B. Now, Mr. A knows that Mr. B will attach and execute the properties of Mr. A. So, what he did before the execution, he sold the lot to his driver. So, because in cases of attachment and execution, you can only attach and execute properties belonging or under the name of the debtor. So, what Mr. A will do, he will sell his house and lot and car to his driver. Okay, so Mr. B cannot do anything or cannot execute any property of Mr. A. So what he will do, the Mr. B, the creditor, may go to the court and ask for rescission of the contracts because it was done in order to defraud Mr. B. However, you have to prove that indeed the contract or the transaction was in order to defraud the right of the debtor. So those are the three remedies of the creditor in case he cannot, what do you call this? The debtor fails to do his obligation. Okay. And then Article 1178, General Rule states that all rights acquired by virtue of an obligation are transmissible, except when it is prohibited by law or by stipulation of the party. So, acquired by virtue of an obligation. So, the when you say rights, the right that is the right to receive the obligation, but not the right because not the right to do the obligation, but the right to receive is transmissible. Okay, but not the right to do or to deliver the obligation. So that ends chapter 2, nature and effects of obligation. Thank you and have a good day.